24th at exactly 6:05 p.m., Ms. Voss. Thank you very much. We'll go right into the agenda. I know I got the script. Let me do my thing. Item number 16 is the second and final public hearing to adopt for the adoption of the final millage rate and budget for the FY 18-19. I have a script here that I'll be reading from. It starts with, County Administrator, you follow me. This is the second of two required public hearings on the Leon County budget for the fiscal year 2018-2019. If you wish to speak, please complete a speaker card and turn it in to the clerk, Ms. Voss. Now, the County Administrator, Vince Long, will read the millage rate into the public record. Mr. Administrator.
Thank you, Mr. Chairman. And again, I will go off the statutorily prescribed script, so bear with me. The proposed aggregate millage rate is 8.8144 mils, which is 3.91% over the aggregate rolled back millage rate of 8.4827 mils. Ad valorem revenues will increase due to an upturn in property values and will be used to support the following: enhanced support of law enforcement and corrections, sustaining a high level of countywide service delivery, continued community investment in parks, greenways, roads, and sidewalks, and the establishment of sufficient revenues in anticipation of the impacts from future potential property tax exemptions. Commissioners, Mr. Chairman, you know that we've been through a very long and very detailed process to this point. We do have a brief presentation should you choose to do so, but I know you've seen it many times up to this point, and everything in this budget reflects your previous action. So with that, Mr. Chairman, I'll hand it back to you.
Thank you, Mr. Administrator. I believe we've all seen the presentation enough times. At this time, the individuals that have turned in speaker cards to the clerk are allowed to speak. Mr. Administrator, do we have any speaker cards?
We have no speaker cards on the budget.
Ms. Voss, are you holding any speaker cards? Florida statute requires the board to address the millage rate before addressing each budget. The board must vote on each millage rate and budget separately. I will now entertain the following motions. Option number 1, adopt via attached resolution the final FY 18-19 countywide millage rate of 8.3144 mils. I need a motion. Motion been made by Commissioner Deloge, seconded by Commissioner Lindley. All those in favor indicate by saying aye. Aye. Any opposed? Motion carries 7-0. Adopt via attached resolution the final FY 18-19 countywide budget. I need a motion. Motion made by Commissioner Lindley, seconded by Commissioner Deloge. All those in favor indicate by saying aye. Aye. Any opposed? Adopt via attached resolution the final FY 18-19 emergency medical services MSTU millage rate of 0.5 mils. Motion made by Commissioner Lindley, seconded by Commissioner Deloge. All those in favor of the motion on the floor indicate by saying aye. Any opposed? And finally, adopt via attached resolution the final FY 18-19 emergency medical service MSTU budget. The motion. Motion made by Commissioner Lindley, seconded by Commissioner Deloge. All those in favor of the motion on the floor indicate by saying aye. That is the end of my script. Mr. Attorney, does that satisfy this item?
Yes, thank you.
We'll move on now to item number 17. Mr. Mr. Administrator. Item number 17, yes, Mr. Administrator. Mr. Attorney.
Mr. Chairman, you have before you a public hearing that has been noticed. However, after the notice was published, we received a request from the applicant through their counsel to have this matter continued indefinitely. So I would recommend that you adopt a motion to continue the matter, and then when it comes back, it'll have to be re-advertised.
Sir, second. I'm sorry. Motion by Commissioner Lowe, seconded by Commissioner Lindley. All those in favor of the motion on the floor indicate by saying aye. Any opposed? Motion is continued. Item is continued. Item number 18.
Mr. Chairman, you have before you a quasi-judicial appeal of a residential development site plan. Just walk you historically through that. This was approved by staff at the DRC level. Subsequently, an appeal, if you're using that term generally, was lodged under our ordinance. There is a process that is followed, and it involves essentially a special master. We have a contractual relationship with the Division of Administrative Hearings who conducts those on our behalf, and so they're conducted by an administrative law judge. A trial was held on this matter, and subsequently the administrative law judge, after proposed orders were filed, entered a recommended order, which comes to the Board of County Commissioners, upholding the decision of the Development Support and Environmental Management staff, which approved the submission with some conditions. It now gets scheduled before you for a public hearing, and procedurally, this is how it's going to sort of shake out. It's also an advertised public hearing, so we would take public comment, those who have submitted speaker cards first. When those are concluded, then the petitioner or the petitioner's counsel have 20 minutes combined to make a presentation to you that is all that they get, and to argue that the proposed recommended order should not be approved. After that, county staff and the applicant would have an opportunity for, if you would, their presentation. I don't know whether each of those parties is going to do so, but they have that opportunity as well. Ms. Voss has rearranged the 3-minute ticker to reflect a 20-minute time limit on each, and we're going to use the red. I was going to use my watch, but that's a lot better to have the timer in use. Plus, you can see the time as it's running on the lectern. And so there is a procedural issue which we're going to need to dispose of. At some point, my suggestion is that we hear from the public speakers. Then I'm going to interject with a request to ask you to deal with the exceptions which were filed by Attorney Braswell, and then we would get into the petitioner's presentation. So Mr. Long has agreed to be my left-hand man here and call the speakers as we would normally do.
Thank you, Mr. Attorney. We'll start from the top.
Mr. Chairman, the first speaker is...
Hold on.
Question, point of order. There are two petitioners. There's Ms. Goodman and Ms. Braswell. Is that going to be 20 minutes
No.
for each, or is that 20 minutes total
20 minutes
between
total.
the two of them? Because they have different interests
20 minutes total for the petitioners.
for both.
Yes.
No, so not
No.
each.
2 minutes total.
Understand?
Yes.
The first speaker is Linda Leach.
My husband and I bought our house about not quite 3 years ago on the east side of Palafox. When it rains really heavily, we own half an acre, and part of our half acre goes back into the conservation area. And when it rains really hard, that is flooded. My concern is there'll be even more flooding with this new development, and it will encroach even further on, maybe even into our houses. Thank you.
Thank you, ma'am. Next speaker.
Next speaker is George Lewis.
Thank you, Mr. Chairman, Commissioners. George E. Lewis, 2nd, 203 North Kedron Street, number 6. I'm here representing the Friends of Lake Jackson. If the instructions of a prior commission had been followed, we would not be here on this agenda item tonight. When the lake protection category of the comp plan was first described, the commission said that they wanted all of the land inside the urban service area that was inside Lake Jackson Basin, that was part of the county, unincorporated county, to be classified as lake protection. this site would have been included in that designation. However, at the time, the map showed that somebody thought it was in the Lake Lafayette Basin, and the thing was mapped as mixed-use A, which would have allowed this application to go forward. It would not have been permitted under lake protection. In the late 90s, a prior owner of the property for Palafox Preserve began development plans and had to comply with the environmental requirements. In that process, they delineated in 2001 the wetland that was accepted by the county in the wetland designations. In 2006 is when the county approved the natural features inventory and incorporating that 2001 determination. Under the application before you now, there has been no update of that 2001 survey, wetland delineation, nor any requirement that the applicants bring forward any further evidence of the current conditions. In spite of the fact that Section 10-402.8B2II requires that an applicant include a site map depicting the existing natural and developed features on the parcel. What this boils down to is you're faced with a request to go forward with the 2001 existing conditions that have been changed by the creation of a total retention pond on the entire site and building a road across some of this area. So at a very minimum, we request that you require an amendment or a condition to this that they redo the environmental application and go forward if the item has changed, if the area has changed, that you require it be remapped and the buffers be reconstructed across it. Thank you.
Thanks, sir. Next speaker.
The next speaker is Vicki Goodman.
Name and address for the record, please, ma'am.
Sorry?
Name and address for the record.
Vicki Goodman, 2800 Palafox Lane. I'm here today as a resident of the neighborhood that's being impacted by this development. I'm on the very lowest downhill side of that neighborhood. The proposed development is uphill from us. I want to start by, first of all, talking about a couple of things. I hope you provide some latitude. Let's talk about, first of all, that we would not be here if the public hearing process had worked appropriately for us as neighbors. We know that these are formalities. We have learned a lot in the last 4 years about what a public hearing is all about. We always thought that it was about going and stating our concerns and getting some answers and direction from those particular agencies. Instead, we found out that nothing is really done at a public hearing except that we stand up and they go forward with their business as usual. Had we had any kind of acknowledgement, consideration, or answers or assurances, we would not be here today. The stormwater facility has been changed on Lot B totally differently than we have expected from the papers that we bought our houses for. It is going to create a lot more water. You will hear testimony that says that that water is only going to add a certain amount that's contained in the smaller stormwater pond, because if it dumps totally into the common area and the private property without permission onto our property, that it will only raise the water level by a very minimal amount. Unfortunately, that's if it was one can dumping into the bowl of the conservation easement and our private property. It is not one can. It is a can that dumps and continually fills and pours water. We have already been flooded. You're going to hear testimony about that. And I ask that you consider, they have a new engineering study done to talk about the changes that were done without our permission as required by our contract in our particular covenants and restrictions. I am going to, at this time, relinquish the rest of my time to the other petitioner, Jeff Braswell.
The next speaker is Ronnie Collins.
He doesn't care to speak.
Scott Hampton.
Hello, all the commissioners. Thank you for allowing us to have this discussion. I just want to bring up 3 issues that I brought up at the last public hearing, and 2 of them were not answered. One was partially, but I'll share the first one, and that is safety of the public and of the children at Gilchrist Elementary School and in the neighborhood. This is a map of the area. When this development was proposed in 2014, none of these blue things were in the system. Island Wings, many of you have been there. The Grove, there's 160 cars in that parking lot 7 days a week. The big park we're building right here. And then we don't know yet what's in the movie theater or the hotel, but all this development in the Market Square. So all the blue is new. Here we are in the yellow, and here's the pink, the new development. And there's Gilchrist Elementary. So I brought up a concern. We have a lot more traffic going to be coming through here, and we have little children right across the street. And I asked if they could do another survey and another study for the traffic. And I was told that that was a city issue, not the county issue. No one answered my question. It was not resolved, and that's what I was told. Second issue I brought up was light pollution. As you see here, here's our 9 homes in yellow and gold, right across this little easement. And then here, the pink is their buildings. They're going to have 36 houses, 3 stories high. Right now, I look out back my backyard, and the 9 neighbors next to me, we see the stars and the moon and a couple planes going over at night. So I had a concern. Has anyone looked at light pollution? No one answered my question. My third question was about the flooding. That's my concern. As you know from the Canopy Road situation, here's a picture from the front page of the Tallahassee Democrat. They're flooding all over the water there on Centerville Road and so forth. Well, here in this development, the flooding is not the road. That could be a victim of the flooding, but it's our backyards. Here's a picture of my backyard with ducks swimming in it. When there was a high water line for several months, the entire half of my yard is covered in water. Right now, my house sits 1 foot above this water line where these ducks are enjoying my backyard. 1 foot of elevation. Those 36 houses are uphill, and the only place for that water to go is our direction. So my concern is obviously the flooding issue, because as you can see, this runs downhill, and we're the ones on the other end. So when I asked the county, who do I call if we're flooded? And I was told to call our original developer 5 years ago, who designed a great housing area for our 19 homes, and it has kept us dry. No flooding, it's great. But I'm not sure how the old developer is supposed to be responsible for the new development and all the water that comes down. Fortunately, the engineers did come out and look at our concerns, and I thank them for that. They came out and looked at the drainage and have an idea of what this is all about. So I have no doubt that they'll listen if I have to call them if we do flood. I thank you for this time. Appreciate it.
Thanks, sir.
That concludes the speakers on this item.
Mr. Turner?
Mr. Chairman, at this point, prior to the presentation by the petitioners, you have a memo from me from September 21st, Friday. We received on Friday a set of documents listed as exceptions from Mr. Braswell on behalf of his client. The recommended order from the administrative law judge says that any exceptions need to be filed within 10 days of the date of the order. The order was August 31st, is my recollection. In any event, that 10-day period ran, and when the exceptions were filed, it was 20 days after the date of the recommended order. The order also says that any exceptions need to be filed with the clerk of the Board of County Commissioners. These exceptions were filed with the Division of Administrative Hearings. So for the untimeliness issue and for the erroneous filing, we believe that these exceptions are not properly before you, and we would request that the board consider a motion to strike from the record the potential exceptions which were filed last week.
Mr. Turner, you suggest we do that before we hear the petitioners?
Yes, because it sets the stage for what the petitioners would be able to argue.
Is there a motion?
Yes.
Motion made by Commissioner Lindley, seconded
I'll second.
by Commissioner Dozier. Mr. Attorney, is there any, from the board, is there any discussion?
Just
Commissioner Dozier?
one quick comment, Mr. Chair. I think it's, since we've had several